how exactly do we govern ourselves? I mean, we all live our lives bound by laws, but where do they actually come from? Do they come from nature, from some divine sense of reason, or just from whoever happens to be in charge at the time? We're going to unpack all of this today, looking at the very architecture of rules. So, to start us off, I want to pose a core philosophical hook to you, one famously illustrated by the 20th century legal philosopher H.L.A. Hart. Imagine a gunman walks into a bank, points a weapon at the teller, and demands all the money. The teller is forced to obey, right? Now think about the government demanding you pay your taxes. You're also forced to obey. So what's the difference? Aside from the fact that the IRS usually sends a mildly polite letter first, what actually separates forced obedience from a genuine legal obligation? Keep that question in the back of your mind as we go. Here's our quick agenda for today's explainer. We'll start with the concept of law, move into the big debate between natural law and legal positivism, explore reason as the spirit of law, break down how model rules are structured, and finally, look at a real-world Supreme Court case to see how all this theory applies in reality. Okay, Section 1, the concept of law. What is a law? Let's dive right into defining the fundamental building blocks of legal theory. Let's go back to our bank robber scenario. An earlier philosopher named John Austin had this thing called the command theory. He argued that law is literally just a series of commands backed by threats from a sovereign. But H.L.A. Hart came along with a brilliant critique of this. You see, the bank robber's command is purely coercive. It just forces obedience in a very narrow, specific scope. But a valid legal rule, it's so much more than that. Laws don't just threaten us, they actually facilitate our lives. They allow us to create contracts, get married, draft wills. Plus, laws apply broadly to everyone, even the very legislators who write them. A law isn't just a threat. It's a foundational, structural rule of society. And this brings us to a huge, major school of thought, legal positivism. Under legal positivism, laws are just rules created by humans, specifically human authorities. The defining, absolutely crucial feature here is that there is no inherent or necessary connection to morality. To a positivist, a law is a law simply because it was passed by the proper authority, like, say, your local city council. It doesn't matter if it's a good law or a terrible, wildly unjust one. Its validity comes purely from its source, not from its moral content. Section 2, Nature, Morals versus Rules, the natural law tradition. Now, that positivist view raises a pretty massive problem. If positive laws are just human commands, what happens when a command is fundamentally, undeniably unjust? Well, this leads us to the opposing heavyweight in legal theory, natural law, or is naturalism. This tradition argues that you literally cannot just separate law and morality like that. Instead, it posits that there are objective, universal, moral standards derived from nature itself. These inherent laws aren't just invented by politicians in a room somewhere, they are discovered by humans through the use of reason. In this view, a legal standard absolutely must have a basis in morality to be truly valid. Perhaps no one captured this better than the 13th century philosopher Thomas Aquinas. Think about the sheer gravity of this statement. He boldly claimed, an unjust law is not a law, it is a perversion of law. Aquinas synthesized classical philosophy with Christian theology, arguing that human laws absolutely must conform to natural law. If a human authority passes a law that violates universal moral principles, it loses its true legal essence entirely. It just becomes a perversion, a fake, a mere imitation of a law. And this brilliantly illustrates the central dialectical clash in jurisprudence. Natural law bases itself on universal morality, says law is discovered in nature, and requires it to actually be just. Positivism, on the flip side, bases itself on human authority, says law is created by society and only requires it to be enacted properly by the rules. It's the ultimate debate of what law ought to be versus what law actually is. Section 3, Reason, the spirit of law, the human connection. So, the crucial point here is figuring out how humanity actually bridges the gap between eternal, universal nature and the everyday rules we live by. And the answer, across centuries of philosophy, is reason. The ancient Roman philosopher Cicero provided one of the most eloquent definitions of this. He wrote, "True law is right reason in agreement with nature." For Cicero, reason was the great unifier. Because all humans possess reason, we can all tap into this universal natural law. It obliges us to contribute to the general good of society. If a statute was wicked or unjust, Cicero believed it simply wasn't a law, period, because it lacked this foundational right reason. Centuries later, this concept evolved into the very foundation of English common law. Sir Edward Coke, who was a preeminent 17th century jurist, adapted this ancient idea, stating, "Law is perfect reason." Human nature and reason dictated the very purpose of the law itself. Now, this was a massive, game-changing idea, because it meant the law was superior to any single person's arbitrary will, even the king. No one gets a free pass. No one is above the law. It's rooted in reason, meant for our mutual preservation and direction. Now, what's really fascinating here is how the philosopher Thomas Hobbes used reason to distill natural law into highly practical, survival-oriented social rules. Hobbes lived through the chaos of the English Civil War, so his focus was entirely on avoiding that kind of chaos. Through reason, he deduced these laws of nature, primarily that humans should seek peace, be willing to lay down absolute freedom to maintain that peace, and keep the contracts they make. For Hobbes, reason wasn't just some abstract moral high ground. It was literally the ultimate toolkit for human survival and social order. Section 4. Primary and Secondary Rules. Structuring Society. Let's jump back to the 20th century with H.L.A. Hart to see how a modern society actually takes these reasoned concepts and structures them into a functioning legal system. Hart argued that a true legal system isn't just a giant list of commands. It's the union of two specific types of rules. Step 1. Primary rules. These are your standard rules of conduct. They dictate obligations, like don't steal or don't murder. But a society with only primary rules is totally static and inefficient. So we need step 2, secondary rules. These are rules of empowerment. They tell us exactly how to recognize, change, or judge those primary rules. Think of the rules that allow a Congress to pass a new bill or a judge to rule on a contract. The union of these primary and secondary rules is what actually creates a dynamic, living legal framework. But how do these rules actually stick? Hart made a really vital distinction here between a mere social habit and a true social rule. Going to the movies every Thursday, that's a habit. If you stop going, no one is going to punish you or think you did something morally wrong. But a social rule, like stopping at a red light, carries what Hart called an internal aspect. It's that critical feeling of obligation. We look at the rule as a standard for our own behavior and as a justification for criticizing others who break it. That internal sense of obligation is what gives law its true normative power. Section 5. Applying the law. Theory meets reality. Okay, let's see how this all builds up when abstract philosophy finally meets concrete, real-world case law. How did these structured, human-made rules actually operate? We're going to look at a specific 1970 ruling from the Supreme Court of the Philippines, Tecson versus Salas. This case involved a man named Jose Tecson, a superintendent of dredging, who sued to nullify his detail to the office of the president. He claimed it was essentially a backdoor removal without cause. This is a totally perfect example of secondary rules of adjudication being used to interpret the primary rules of a government structure. The Supreme Court actually dismissed Tecson's petition. The quote highlighted here gets right to the core of their reasoning. They affirmed the establishment of a single executive. By constitutional law, the executive power is vested solely in the president. What does that mean for us? It means the president has the ultimate power of control over all executive departments, bureaus, and offices. The president absolutely has the right to interfere or act in lieu of those officers. Therefore, detailing Tecson to another office was entirely 100% within the president's constitutional authority. So, emphasizing the takeaways here, this case is a stellar example of legal positivism in action. The court wasn't sitting there debating the universal natural law morality of Tecson's job transfer. They were strictly interpreting the human-made, positive constitutional law of the land. It completely validates the alter ego doctrine, where executive officials are essentially extensions of the president's power. And it beautifully demonstrates Hart's theory. The Supreme Court used secondary rules of adjudication to reinforce and clarify the primary structural rules of the sovereign government. Which brings us to the very end of our journey today, and I want to leave you with a final, slightly provocative question to chew on. Think about the laws you obey every single day. Are they truly rooted in a universal, natural, moral reason? Or are they simply legal positivism at work, human habits and rules backed by the sheer authority of the state? It's a question that has defined human history, and one that every society has to continually ask itself. Thank you so much for joining me on this explainer, and definitely keep questioning the rules around you.